Namaskar everyone and welcome back to my channel Legalese by Aditi Sahai. So from today onwards I'm going to cover legal maxims and today's topic and maxim is Nemo, debet, esse, judex in propria, causa. Its literal meaning is no one ought to be a judge in his or her own case. Its origin is from Latin. It is a principle of natural justice. According to this maxim, the authority giving decision must be composed of impartial persons and should act fairly and without biasness. It is a fundamental concept in the administration of law to exercise justice and fair hearing. The term natural justice can also be titled as fundamental justice and substantial justice. In simple words, fair hearing implies that no man shall be condemned by the authorities without being heard on the case. There are types of biases, for example, such as personal bias, which is this kind of bias may arise from out of friendship, relationship, and professional grievances or even enmity. Second, pecuniary bias. Nonetheless, it is evident that the decision of adjudicator would be affected if he has a pecuniary interest in the subject matter of the proceeding. Third, official or subject matter bias. When the situation arises in which a judge possesses a general interest in the subject matter of the dispute, it is referred to the officer or subject matter bias. For example, A files a suit against B, which has been scheduled to hearing before Judge C. After all the arguments and hearing, Judge C passed an order in favor of the B. However, it is found later on that this C was an acquaintance of the B. Thus, it can be held that the decision of C must have composed of partial persons and should act fairly. Let's move on to the case laws. Mm, In the Govindaraja Mudaliar versus State of Tamil Nadu, the government decided in principle to no, in principle to nationalize road transport and appointed a committee in which Home Secretary was made a member to frame the scheme. Later on, the scheme of nationalization was published and objections were heard in the Home Secretary. It was contended that the hearing was vitiated by the rule against the bias because this home secretary already made up his mind on the question of nationalization as he was a member of the committee which took this policy decision. The Supreme Court rejected the challenge on the ground that the secretary as a member of the committee did not finally determine any issue on the force foreclose his mind. He simply helped the government in framing the scheme. So thank you everyone and keep liking, sharing and commenting on my reel. Highly gratitude.